Guys, you have to see this. Ripple's chief legal officer, Stuart Alderoty, has voiced optimism over the proximity of the firm to the conclusion of the litigation brought by the Securities and Exchange Commission. This remark was made by him not long after the Securities and Exchange Commission made public its response to Ripple's opposition, which discussed remedies, along with supporting papers. Ripple is coming closer to putting the litigation behind it, according to Alderoty, as a result of the SEC's response to the remedies. Alderoty, in the meantime, noted that although Ripple is now on the verge of seeing the conclusion of the SEC litigation, it is regrettable that other cryptocurrency startups are just beginning the process of legal fight against the regulatory agency. The Securities and Exchange Commission filed a lawsuit against Ripple in December 2020, accusing the payments business of breaking U.S. securities laws by issuing and selling XRP as an unregistered asset. For those who are not familiar with the case, the litigation officially began in December 2020. In particular, the legal battle had a devastating effect on Ripple's business and the cryptocurrency XRP, which is linked with it, particularly in the United States. Multiple trading platforms in the United States, including Coinbase and Kraken, delisted XRP at the same time as Ripple shifted its business strategy to concentrate primarily on business with customers located outside of the United States. It is interesting to note that once Judge Alyssa Torres found XRP programmatic sales to be non-investment contract, several exchanges altered their positions and relisted the coin. In spite of the fact that it has been almost 3.5 years, the legal action is still being pursued. In spite of this, the final response from the SEC moves Ripple one step closer to the conclusion of the legal battle that has lasted for several years. Immediately after receiving the response from the SEC, Judge Torres will now set a date for the announcement of the final verdict. Popular crypto specialist Ashley Prosper anticipates that the ruling will be made public between the months of July and September, despite the fact that it could be made public at any time. However, other cryptocurrency-related businesses such as Coinbase, Binance, and Kraken are just beginning their own operations at the same time that Ripple is getting close to the finish of its fight. Wells notice has also been issued by the SEC to Ethereum and Robinhood, which indicates that an enforcement action is likely to be taken in the near future. While this was going on, Alderoty made a remark on the SEC's response to the remedies matter. He accused the regulator of misleading the judge by not applying the law in a faithful manner as part of his attempts to deceive the judge. Even yet, the chief legal officer of Ripple anticipates that the judge will make a decision regarding remedies that is impartial and fair. Alderoty made the observation in a subsequent tweet that the Securities and Exchange Commission disregards other foreign financial regulators in its most recent filing. Ripple's chief legal officer stated that the Securities and Exchange Commission compared the cryptocurrency licenses provided by various international regulators to mere phishing licenses. It was an excerpt from the SEC's reply brief that he attached, which demonstrated how the SEC had made the categorization in a different way. In its response, the Securities and Exchange Commission issued the following statement. This claimed Ripple using the licenses it obtained from other jurisdictions to back up its claim of not planning to violate U.S. securities laws in the future is comparable to saying that a New York restaurant does not need to obtain a liquor store license because it obtained a fishing license in California. An announcement about Ripple XRP from Judge Jeremy Hogan is anticipated shortly. If you ask Hogan, he is certain that XRP will not be considered a security. In the continuing dispute, the attorneys for Ripple and the Securities and Exchange Commission have presented their arguments. Ripple, an American financial technology business, has had a senior attorney and partner from the firm file a brief in support of the blockchain payments company in the continuing litigation that the SEC has initiated against it. Discouragement and lasting injunctions are the central themes of all the publications in response to the sex's assault on Ripple. The company's chief legal officer, Stuart, has taken advantage of the situation to attack X and question the SEC's dedication to equitable law enforcement. The SEC argues for stricter penalties in its recent court filing. Notwithstanding the 3-year battle, the SEC has maintained that Ripple's core business, the unregistered sale of XRP, has remained unchanged since 2013. Therefore, the CK maintains that permanent injunctions are required to stop Ripple from making the same mistake, regardless of whether the company hasn't broken any rules since 2020. This goes against Ripple's argument that the SEC's standards are too high. According to the SEC's earlier brief, Ripple's behavior indicates the likelihood of another violation. but the Securities and Exchange Commission has responded to this accusation. According to the counterargument, Ripple's initial promise was an attempt to repeat the summary judgment argument and not an assurance. According to the SEC's most current list of remedies, the firm is to blame since Ripple either misunderstood or chose to ignore the decision that establishes a permanent injunction that forbids the company from carrying on with its operations. This leads the SEC to unleash, in a strong response to the SEC's final remedies brief, Ripple's chief legal officer, Stuart Alderoty, criticized the agency's approach following the brief's publication. Regarding the SEC's efforts to deceive the judge and their disregard for the law, Alder made the following comment on XMore. The U.S. Securities and Exchange Commission's disregard for international regulatory systems was also something he spoke out against. Providing thorough crypto licensing frameworks is like handing out fishing licenses, just when you thought things couldn't get worse with the SEC. The SEC has granted you fishing licenses, financial stakes, and a decision is on the horizon if you are a financial regulator outside of the U.S. who has laboriously toiled to build comprehensive crypto licensing framework. In its most recent brief, the Securities and Exchange Commission made it plain that it would not be resenting the demand for fines and penalties totaling $2 billion. Securities and Exchange Commission undercut Ripple's defenses against disgorgement by pointing to the ludicrous sums the company claimed to have earned from its unreported XRP sales. Certain institutional investors suffered financial losses because Ripple failed to disclose pricing and discounts. According to the SEC's findings, these investors would not have paid as much had they been provided with all the relevant information. The most current brief from Ripple argues that the SEC's expectations were too harsh and that a sentence below $10 million would be more reasonable. Compared to the proposed penalty amount, this is significantly lower. The efforts made by Ripple to resolve the issue have led Chief Legal Officer Mr. Alderoty to express hope about the future of the company. At this point, the only thing remaining is for Judge Sarah Nett Byrne to go over the brief and announce a final verdict. A precedent for future enforcement cases in the cryptocurrency business will be set by the outcome of this, which will determine the upholding or settlement of the SEC's injunctions and discouragement claims. In light of an impending critical decision, Ripple may reassess its on-demand liquidity offerings. If the remedies proposed by the SEC are put into action, Ripple's institutional sales could be impacted by strict injunctions. A watershed moment will be marked when the court's decision defines the legal standing of XRP sales after the complaint. Quickly approaching is the next stage of the litigation involving Ripple Labs Inc. and the U.S. Securities and Exchange Commission. The SEC will soon provide a redacted version of their final remedial reply brief for the public to review. It is on this brief that the judge will soon render his decision. Recent events have the potential to disrupt Ripple's business model as well as the cryptocurrency industry as a whole. That's all for now.